The right to trial by jury is deeply embedded in the history and culture of free societies. 1215, the time of King Richard, the Crusades, and Robin Hood. Angry barons surround King John on a grassy knoll and impose upon him the Magna Carta. This most famous document of British constitutional history placed the king's power in check and laid the groundwork for a guarantee of trial by jury. 1776, Thomas Jefferson pens our nation's Declaration of Independence, listing the colony's grievances against the King of Great Britain.
He has combined with others to subject us to a jurisdiction foreign to our Constitution, and unacknowledged our laws, giving his assent to their acts of pretended legislation, for depriving us in many cases of the benefits of trial by jury.
1789, the states debate our country's constitution. Arguments are heated and ratification stalls until the Bill of Rights is introduced. This, the Seventh Amendment.
In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law.
As the United States expanded from sea to shining sea, people whose heritages varied as widely as the landscapes they settled on continued to reaffirm the importance of the right to trial by jury. Today, 49 of our state's constitutions specifically guarantee that right, with language such as this.
The right to trial by jury shall remain inviolate, and shall extend to all cases at law without regard to the amount in controversy.
Today, the importance of the right to trial by jury is even being recognized by countries that have endured many years of communist rule. Government officials in Czechoslovakia and Russia have invited the American Board of Trial Advocates to their countries to demonstrate how a civil jury trial works. Why have people of great vision all through history placed such emphasis on the right to trial by jury? Why is it so important? The right to trial by jury is one of the most fundamental principles of our government and our society. It assures that a jury of your peers, not politicians, not bureaucrats, will decide what is right and what is wrong. On a jury, people from all walks of life come together to enforce our society's beliefs of morality and fairness. Juries are powerful. At times, they decide the fate of a single human life. At other times, they are charged with protecting millions of people and their businesses. Many believe the Seventh Amendment is the glue that holds democracy together. Thomas Jefferson called the jury system the public's line of defense when the government acts oppressively, and he deemed the right to trial by jury even more important in a democracy than the right to vote. Former Supreme Court Justice William O. Douglas has said that the jury is the only agency of the government with no ambition and no political gain to be had from their verdicts. The jury's role is essential to the system. Federal Judge George H. Bolt once wrote, "Jury service honorably performed is as important in the defense of our country, its constitution and laws, and the ideals and standards for which they stand, as the service that is rendered by the soldier on the field of battle in time of war." Those Americans who have participated in the jury system as jurors also give it high marks. Over 80% of jurors questioned in a recent survey have a favorable attitude toward jury service. In today's society, our legal system is often the target of criticism. Ironically, that freedom of speech is one of the rights the system protects. We've all heard about the alleged explosion of claims and big-dollar jury awards. But if you examine the facts, you'll find that the jury system is working very well. In fact, Americans today file fewer suits per capita than did their colonial counterparts. For example, in 1639, the litigation rate in Accomack County, Virginia, was 240 per 100,000. That's more than 4 times higher than any county in the United States today. And in 1683, 1 of every 10 adult male citizens in Salem County, Massachusetts, was involved in a lawsuit. Even today, recent surveys indicate that the filing of lawsuits is increasing at a smaller proportion than the population is increasing. As for the alleged explosion of big-dollar jury awards, in a report to Congress, the General Accounting Office had this to say about product liability suits. GAO found that damage awards were not erratic or excessive. Also, consider this comprehensive study of punitive damage awards in product liability cases over the past 25 years. Researchers found that only 355 punitive damage verdicts were returned by state and federal court juries between 1975 and 1990, an astonishingly low number. 1/4 of those awards involved a single product, asbestos. In an independent study on medical malpractice claims, Harvard College researchers stated, "We estimated that 8 times as many patients suffered from an injury from negligence as filed a malpractice claim. About 16 times as many patients suffered an injury from negligence as received compensation." Minnesota Commerce Department Commissioner Michael Hatch also studied medical malpractice claims. His report says, "It is obvious that insurers are charging considerably higher rates than are necessary to cover losses and expenses and also realize a healthy profit. Fewer than 0.5% of all malpractice victims are awarded damages by a jury." The rising cost of health care has become one of the most important issues of our time. Americans are spending $650 billion each year for health care. Some project that cost will exceed $1 trillion by the year 2000. Despite what some people believe, only a very small percentage of America's total health care cost is related to litigation and the use of our legal system. The cost of medical malpractice settlement payments represents less than 1% of our nation's total health care costs. The American Board of Trial Advocates recognizes that no system of government or law is absolutely perfect. That's why we have carefully authored our civil justice reform proposals. Instead of sweeping changes that limit our freedoms, we recommend common sense solutions to the problems most often cited by advocates of tort reform. Solutions that fine-tune our legal system while maintaining our constitutional rights. Our justice system is the shield that separates us from the oppression that citizens of many other countries face each day. In some parts of the world, people still fight and die for the right to have their lives governed by the people, for the people. In America, we are fortunate that our forefathers have already fought those battles for us. Now it is our duty to uphold this principle of the right to trial by jury. We must come together to do justice and to preserve justice for those who trust us with their future. That charge is as important today as it was in 1801, when Thomas Jefferson delivered his first inaugural address.
Equal and exact justice to all men. Freedom of religion. Freedom of the press, freedom of person under protection of the habeas corpus, and trial by juries impartially selected. These principles form the bright constellation which has gone before us and guided our steps through an age of revolution and reformation. The wisdom of our sages and the blood of our heroes have been devoted to their attainment. They should also be the creed of our political faith. And should we wander from them in moments of error or alarm, let us hasten to retrace our steps and regain the road which alone leads to peace, liberty, and safety.